Imagine a towering stone pillar. It looks entirely solid, but a microscopic fracture has compromised it since the beginning. In family law, a standard divorce dismantles a union that has eroded over time. Nullity, however, targets a marriage that was inherently flawed from the start. We classify these flawed unions in two ways. First is the void marriage. This is a legal fiction, a union that never existed in the eyes of the law because of severe defects in capacity or formalities, like bigamy. But a voidable marriage is different. Look at this official marriage certificate. It remains a completely valid, legally binding contract until a court explicitly steps in to annul it. Because the state actively recognizes the union, the burden rests entirely on the petitioner. They must proactively apply for a nullity order to sever that binding status. You cannot annul a voidable marriage simply because the relationship deteriorated. General marital unhappiness, infidelity, or a gradual breakdown of affection are entirely irrelevant here. To erase the marriage, you have to prove a specific formation defect. That brings us to Section 12 of the Matrimonial Causes Act, 1973, which provides the exclusive, rigid statutory framework governing voidable marriages. Section 12 outlines exactly 8 exhaustive grounds that make a marriage voidable, organized into subsections A through H. If your case does not fit one of these 8 slots, you cannot get an annulment. To make sense of these 8 disparate rules, we can categorize them into 3 logical pillars: consumption, consent, and concealed status. To dismantle a legally recognized union via nullity, a practitioner must abandon general grievances. They must prove a highly specific statutory defect occurred the precise moment the marriage was formed. The first pillar of Section 12 focuses on the physical threshold, consumption. This is governed by subsections A and B. Subsection 12A deals with incapacity. The court requires proof the inability to consummate is permanent and incurable, whether physical or psychiatric. Crucially, under 12A, either party is eligible to apply. A petitioner can even rely on their own incapacity. Meanwhile, subsection 12B covers willful refusal. This requires a settled decision by the respondent not to consummate without a just excuse. What counts as a just excuse? If a couple agreed before the wedding to delay consummation until a specific religious ceremony took place, that agreement could defeat a willful refusal claim. There is a strict statutory limitation to note here. These 2 non-consummation grounds apply exclusively to heterosexual marriages. They cannot be used to annul civil partnerships or same-sex marriages, but they do offer a major procedural advantage. Unlike most other grounds, the standard 3-year time limit to apply does not constrain non-consummation cases. Pillar I relies on the biological and intentional failure to fulfill the physical expectations of a traditional marriage, operating outside standard statutory timeframes. Moving to the second pillar of the framework, we examine defects in consent. A signature might look perfect, but it's voidable under 12C if the consent was compromised by duress, mistake, or unsoundness of mind. The threshold for duress is high. In cases like Harani, it requires proof of undue pressure that completely overbears the applicant's will, meaning true voluntary consent was never given. The law requires proof of an overbearing external force, crushing individual agency until the victim's independent will shatters completely. For mistake, the error must relate to the ceremony's legal nature. A partner lying about wealth won't invalidate the marriage. Then we have subsection 12D, mental disorder, tying directly to the Mental Health Act 1983. This creates a unique legal paradox. A party might be mentally capable of giving basic consent, but their disorder makes them unsuited for the ordinary duties of marriage. Unlike consummation, applications built on Pillar 2 are strictly bound by time. You must file within 3 years from the date of the ceremony. Also note that either party can apply under these grounds, and a petitioner can even rely on their own mental disorder to seek the annulment. Pillar 2 protects the contract's integrity. It proves proper legal formation means nothing if the mind behind it was coerced, confused, or medically incapacitated. The final pillar is concealed status, dealing with hidden realities at the ceremony. 12E covers STIs, where only the uninfected party applies. 12F covers a respondent pregnant by someone else, only the non-pregnant spouse applies. Finally, 12G and H address acquired gender. Under 12H, a marriage is voidable if one party acquired a new gender prior to the ceremony and the other party had no knowledge of it. Subsection 12G covers the scenario where one party acquires a new gender after the ceremony and the other party does not consent to the change in their marital status. If the acquired gender happens post-marriage, the application must be presented within 6 months of the date the gender recognition certificate is issued. Pillar 3 serves as a safeguard against deception or concealed changes to a spouse's status, ensuring parties aren't bound to a union where their partner's identity was obscured at the start. Proving a defect under Section 12 does not guarantee an annulment. That right is heavily constrained by Section 13 of the Act, known as the statutory bars. The first bar is approbation. If an applicant knew they had grounds for nullity but acted like they accepted the union, the court blocks it. The second bar is delay. Most proceedings must be issued within 3 years, or the application is shut down. The third bar is knowledge. For Pillar 3 grounds like an STI, pregnancy, or an acquired gender, the applicant is completely barred if they possessed knowledge of that fact at the exact time of the ceremony. The rationale behind Section 13 is straightforward. The court values finality and equity. It will not allow a party to use a historic formation defect as a convenient exit strategy years after the fact. Once triggered, these statutory bars act as an unyielding, permanent lock, firmly cementing the marriage into legal reality. Section 13 forces applicants to act promptly and consistently. If a defect is accepted, the right to legally erase the marriage is permanently forfeited. So what happens to the status of the couple when a petitioner successfully navigates Section 12 and evades the blockades of Section 13? Because the marriage is voidable, it remains legally valid up until the exact moment the final nullity order is pronounced by the court. You can see in this decree nisi absolute how a standard divorce creates a mechanical dissolution of a once functioning marriage. Nullity is an entirely different legal metamorphosis. The annulment instantly impacts inheritance. Neither spouse will inherit under intestacy rules, and any provisions in a pre-existing will concerning the former spouse automatically lapse under the Wills Act 1837. But despite the union being erased from the books, any children born to the parties remain legally legitimate. And crucially, financial orders for property and maintenance under the Matrimonial Causes Act 1973 remain fully accessible to the parties, exactly as they would in a standard divorce. The entire framework balances on these two sections. Section 12 outlines the strict architectural flaws, while Section 13 enforces the equitable defenses. By mastering this rigid statutory interplay, legal professionals can navigate voidable marriages, not with general arguments of a relationship breaking down, but with surgical, statutory precision.